Good morning, everyone. Thank you for joining the Conference Committee on SB 40. We will now come to order. So last we met, we were talking about some common goals that the House and the Senate had. What had been offered was a Senate position, and the House, I think, was going to go sort of put into action our unified common goals that we had talked about in conference committee on Friday morning. So if I have that right, then, Mr. House Judiciary Chairman, I will give the floor to you for a moment.
Well, good morning, everyone, and you are correct, Madam Chairman. We took those priorities that we talked about Friday morning that we collectively arrived at, and Natalie Scott, and I'm sure with the assistance of Jason Thompson over the weekend, helped put our thoughts into words. And so I will pass this out. Let's see, so hold on one second, I'll bring you some.
Thank you. Is it possible, we have our IT assistant here, is it possible to put that up online at the same time?
I think, Madam Chair, the plan is, if you're okay with it, that Natalie is going to walk us through this, and I think she can share her screen as she goes through it.
That's great. Then we'll ask the reviser, Natalie Scott, to explain the House Bill 21 RS 1683.
Thank you, Madam Chair. And just for verification, Representative Patton, are you okay with me distributing this electronically?
Yes, please.
At this time? Okay. Okay, so you should be seeing my screen now. Section 1 of the proposal deals with schools and the closure of schools. So under the proposal, the only entity that would have the ability to close schools is the local Board of Education, who oversees the school district. Those actions would not have the ability to close any non-public schools. Section 2 of the proposal amends KSA 48924. You'll see the changes made here include replacing the State Finance Council with the Legislative Coordinating Council for purposes of granting extensions of the state of disaster emergency. It also removes the limitation that the extensions can only happen for 30 days. And so it would be up to the council to decide how long that extension would last. Current law in KSA 48924 sunsets the ability to have those extensions on March 31st of this year, and so that would remove the sunset there. The next section, section 3, amends KSA 48924B. And this section is the section of law that extends the state of disaster emergency. And so we make clear that the disaster was extended through March 31st of this year in Senate Bill 14, and then we continue it again to May 28th of this year. There's also in current law a prohibition against that the governor would not be able to declare a new state of disaster emergency related to the COVID-19 pandemic during 2020 or 2021. We add some language here that it would be a disaster related in whole or in part to COVID-19, including any economic, financial, or other crisis that is caused by the COVID-19 health emergency. And then we again, change that extension language to the Legislative Coordinating Council instead of the State Finance Council. Subsection C revokes all the current executive orders that are in place related to the state of disaster emergency on March 31st of 2021. All those would be null and void. And then any new executive order that is issued pursuant to this specific state of disaster emergency would be subject to revocation by the legislature, by concurrent resolution, or by the Legislative Coordinating Council. Under the typical framework, when the legislature is in session, the legislature would be responsible both for extending and revoking executive orders. But for this particular state of disaster emergency, a new executive order would be able to be revoked by the Legislative Coordinating Council even while you guys are in session. Section 4 amends KSA 48.925. We again are making conforming changes to switch extensions over to the Legislative Coordinating Council instead of the State Finance Council. The Legislative Coordinating Council would be the group then who is required to review the executive orders that are proposed during this state of disaster emergency. We do add an exception here because we are granting the Legislative Coordinating Council the ability to revoke those executive orders even while you're in session. So that's the purpose of that statement there. This subsection here is just dead law. It expired on September 15th of 2020, so we're removing that. Subsection G here adds the judicial review of these orders. So any executive order that's issued that has the effect of substantially burdening business, commercial activity, religious and civic operations would be able to be brought in a petition for a civil action by someone who is aggrieved by that executive order. They could either bring that where they live or in Shawnee County. The court would have to conduct that hearing in 72 hours. And then they would have to grant the relief requested if, or unless the court finds that the executive order is narrowly tailored to respond to the state of disaster emergency and uses the least restrictive means to achieve that purpose. So a strict scrutiny standard would be there. The court would be required to issue an order on that petition in 7 days. And if the court didn't do that, then the petition for relief would be granted. Relief under the section would not be able to include a stay or an injunction that goes beyond the county in which the petition was filed. And in order to facilitate the efficient adjudication of hearings under that section, the Supreme Court would be able to adopt rules for efficiency. We also, here in subsection H1, we retain the current law that the Board of County Commissioners can adopt a less stringent order. We just make kind of a clarifying amendment that if the board does do that, they adopt a less stringent order, then that order is the one that operates in the county instead of the statewide executive order. KSA 48.925A is the current prohibition on business closures. So right now, during the state of disaster emergency that's related to COVID, the governor may not issue an order that substantially burdens or inhibits the movement of gathering of individuals, the operation of religious, civic, business, or commercial activity. Right now, that section is set to expire on March 31st of this year, and so we remove that sunset date. 48.932, this is the section related to a state of local disaster emergency. These first few changes are just technical, but the section adds judicial review of action taken by local units of government. So it's very similar to the executive order judicial review. If a local unit of government takes that similar type of action that burdens the movement of individuals, religious gatherings, business, commercial activity, that person can file an action in the county that took that action. The court again would have to have that hearing in 72 hours. They would be required to grant the request for relief. unless they find that the action is narrowly tailored to respond to that state of local disaster emergency and uses the least restrictive means possible. They have to issue an order in 7 days, and if they don't, then the petition for relief is granted. Relief under that section, again, would not be able to include a stay or injunction that applies beyond the county where the action was taken, and the Supreme Court would be able to adopt rules to facilitate the efficient adjudication of those petitions. Section 7 amends KSA 48939. That is the violation section, the remedies section. So you'll see here, we add an exception to that civil penalty, which currently exists. And we say that a knowing violation of an executive order that mandates a curfew or prohibits public entry into an area that is affected by the disaster, that would be a Class A non-person misdemeanor. So we make certain violations criminal under this section. KSA 48949, that's that definition section in the Kansas Intrastate Emergency Mutual Aid Act. You'll see that we're adding 911 call center, public safety telecommunicators, and then we're also adding physician assistants. Section 9 amends KSA 65201. That is related to local health orders. So down here in subsection B, we say if a local health officer determines it's necessary to issue an order that deals with face masks, limiting the size of gatherings of people, curtailing the operation of business, controlling the movement within the population of the county, or limiting religious gatherings, then that local health officer would have to propose that order to the Board of County Commissioners at the next regularly scheduled meeting, or at a special meeting. The board would review that proposed order, and then they can take any action that they want related to that order. If the board took no action related to the order, then the order would become effective. And again, we add that same judicial review language here to those local orders. It's essentially identical to the other two. And then section 10 is just that technical cleanup, KSA 753711. This is a state finance council statute that references their duties under KSA 48924. Since we're changing all that to the Legislative Coordinating Council in this draft, we're removing that statutory cross-reference. And that is everything in this proposal, and I can take any questions.
Thank you, Ms. Scott. Committee, any questions for the reviser? All right, appreciate the work that the House has done. I have a couple questions, just having listened to the reviser's explanation and reading along, if you will. The section 1 regarding schools, does that include community colleges? Community colleges were included in a section in the Senate bill because they're not K through 12, and they're not businesses because they have elected officials on their board. Are they in the bill, or excuse me, yeah, in the House bill here?
Madam Chair, there is no specific reference to community colleges in this draft.
Okay. And then, let's see, I think it was section 2, if I'm correct. Was there something about, oh, I think it's at the top of page 3 that the, in changing from the State Finance Council to the LCC, it was changed also in the House bill that the, I guess the LCC then would be able to extend a state of disaster emergency for a period as determined by the LCC. And it used to be, could be extended for specified periods up to 30 days. So now we're kind of leaving it open-ended up to the discretion and judgment of the LCC. Is that correct on page 3 at the top there?
Madam Chair, that is correct. You'll see that change a couple times right there where you're indicating at the top of page 3, and then again down in paragraph 5. So the
Okay.
LCC would be able to extend for longer than that 30 days under this proposal.
Okay. And then, let's see. Oh, on page 9, page 9 is kind of a continuation from page 8 of subsection C of section 4, where we, or in the House bill, they are enumerating the powers of the governor. They're listed 1 through 11. And is section 11 on page 9, is that kind of the, is that a catch-all for kind of authorities that could be exercised, section 11 there on page 9?
Madam Chair, I think that would be an accurate description of it, kind of it just says that the governor can perform and exercise other functions, powers, and duties as long as it's in conformity with the Constitution and the Bill of Rights and the statutes of the state of Kansas.
Okay, thank you. And section D, right below, again on page 9, regarding firearms and ammunition. It's a little bit different than what was in the Senate bill, which I think also included, I don't remember the exact language, but products and materials needed to produce ammunition and firearms. And that's not in the House bill right now, right?
Madam Chair, the provision related to firearms here in this proposal just retains the current law provision. So this proposal doesn't make any changes to that. And you're right, it does not match the Senate proposal.
Right, I think we had amended that in our committee, but okay, so that's a little bit different there too. And sorry for my hesitations here as I go through this. Regarding the grievance procedures for the executive orders and then the local ones also, we're going right to court with the House bill. We're not going, or an aggrieved person wouldn't be going in front of the local board, or if they feel aggrieved, you'd go right to court. You'd file your petition right in court. Is that the structure of the House bill?
Yes, Madam Chair, those judicial review provisions appear in 3 places. One with the executive orders, a person aggrieved by an executive order. The second is a person aggrieved by local action under a state of local disaster emergency. And then the third is those local health officer orders. And yes, the first stop in all of those would be to be filing a petition in district court.
Okay, and then if you're an aggrieved person by a decision or action of the local school board, do you also have the right to go petition to the court, or what happens in that instance?
Madam Chair, the section 1 provision related to schools doesn't contain that specific language. Of course, that doesn't mean you can't file an action in district court, but it doesn't outline that specific procedure that has to happen for judicial review of those decisions.
Okay. And you were talking about the local unit of government review, and just to make sure, oh, I think that's on page 16 in subsection B2, that if a local health officer, well, it says what it says, that if an issue, if it's determined by the local health officer necessary to issue an order, then the board has to take it up at the next regularly scheduled meeting or at a special meeting, and if the board takes no action related to the proposed order, the order becomes effective. So we're not, in that section, requiring an affirmative vote of the board for the order to become effective. Is that, am I reading that right?
Yes, that is accurate.
Okay. And in that same section, the local health officer could determine it's necessary to mandate the wearing of face masks, limiting size of gatherings, curtailing the operation of business, and limiting religious gatherings and affecting businesses. And okay, so sorry to be reading that out loud. I think that's all the questions I have for the reviser. Committee, does that bring up any questions, or did I miss anything, or that you might have?
If I may just briefly, and all of those are good issues you raised that, you know, may require further discussion. On the last one about the local board, if no action's taken, it becomes effective. That's one we kind of struggled with, trying to achieve what we thought we agreed upon, because our concern has been, what if the disaster results in you not being able to have a quorum of your county commission come together? And so you really do need an order to go into effect, but there's not 2 of the 3 county commissioners that can show up at a meeting. So we tried to put something in that says, as long as they review it at a meeting, whether there's a quorum or not, it would become effective. We're open to other ideas on putting that backstop in place, but something that allows an order to become effective if you can't get a majority of your commission together to vote to approve something. That's kind of the challenge we were trying to walk through or figure out.
Okay, thanks for clarifying that. I had a clarification question on the extension of the declaration to May 28th on page 6. Was there, what was kind of the thought or the reasoning behind that?
Yeah, so over the weekend, just in discussions with the speaker on our side, my understanding, he was then communicating with the president on your side. I didn't have those direct communications, but assuming I'm being passed on what really took place. My understanding is that there was some desire by the governor's office, if we were to do an extension, to go to June 30th, the end of the fiscal year. What I was conveyed back to me is that the Senate president was not willing to go beyond sine die. And so with the reviser, we were originally trying to work through how to put sine die as the extension sunset. It just caused both the reviser and me a little heartburn that we don't know when sine die is, and we won't know that until we adopt the adjournment resolution. And so I passed that back on to the speaker, and he got back with me and indicated the Senate president was okay, suggested May 28th, and I saw no reason to argue with that, and so we used May 28th, the last business day of the month of March. Or not March, May, which hopefully means that if the legislature does work through its proposed calendar, I think the last day we sure will be here is May 11th, and at that point in time, the legislature could consider whether to extend it or not, and then whether we did or not, the LCC could make that determination without us. But that's where the May 28th day came from, was communications, my understanding, communications between the speaker and the president.
I don't know if that's what's been occurring. I wasn't part of those conversations, so, and sine die, the reason it sounds like, well, how come the legislature doesn't know what day sine die is? It's the conclusion, the last day of business, the last day of session, where we are adjourned for the session, and it depends on when the business of the legislature is concluded. So that's why it's a date that's not certain until you get kind of closer to it. So, and it's that way every session, regardless of what else is going on. It's not always set ahead of time because you don't know how long your business will take. Well, that's all the questions that I have at this time. Committee, any other questions or thoughts? And with that, then, we are going to stand at ease so we can discuss the House offer, if you will, on the Senate side. And let's plan on reconvening at 9:45.
Very good,
Thank you very much. I don't mean reconvening. Let's stand at ease. We are not adjourned. We're going to stand at ease until 9:45.
Very good, thank you.
Thank you. Thank you, everyone, for bearing with us while we were standing at ease so we could, on the Senate side, look over the House bill. That was the House offer that was given to us this morning. So it's a 19-page document and does a good job of keeping in mind those sort of common goals that the House and the Senate have in mind. So we're pleased with that. We have a few little tweaks that we need to do here and there, as you can imagine, with a bill this size. It requires a few tweaks. So we're going to take some additional time to look at those. I don't think there'll be anything, hopefully a problem in the little tweaks, but want to give time for the reviser to put those together, which they do a nice job of. So with that then, and I do have at 10:30 have Senate Judiciary Committee. We're working some bills today and a few hearings on some other bills. So with that, then we will continue to put our tweaks together, and they're called balloon amendments, little balloons that will be literally noted to the right of the language that's in the House bill and give the reviser time to do that. Again, nothing that should be different than what we've been talking about the whole time in our unified goals here. So with that, I do have to get to 10:30 committee. I know the House is on the floor at 11, so want to be mindful of those times as well. And we will reconvene at 12:30 today. So with that, unless there are any questions from the committee, we are adjourned till 12:30. Thank you very much. We're not quite sure of the room location yet, but be watching for that to be posted. We're not sure if this room will still be available at 12:30, but either here or somewhere nearby. Thank you.